Good morning and good afternoon to everyone joining from Canada and from other parts of Europe. Um, my name is Sarojini, and I'm part of the Swiss Business Hub Canada, and I'm responsible for investment promotion here in Canada. As part of our job, we're constantly interacting with a lot of tech companies, and protection of innovation is a very integral part of our discussions with companies. And therefore, to address this issue today we have on with us Florian Docomo. Florian is an IP and tech attorney and a legal entrepreneur. He founded HTC, which is a law firm that specializes in technology and innovation, in 2013. In this capacity, he has supported many tech companies over the years. He is also a co-founder of 3 startups, which means that he is very well equipped to understand from the perspective of an entrepreneur any issues or what regulatory and tax issues might come up. He also has a very diversified educational background. He has studied in Switzerland and Germany, and as well as in Canada, and he is an alumni of the McGill University in Canada. We're very happy to have Florian with us today, and we're sure that the presentation will be interesting and informative. So we're looking forward to your presentation, Florian. Over to you.
Thank you very much. Thank you, and hello to everybody. So I'm going to start sharing my screen. Can you see my screen now and hear me?
Yes, we can.
Okay, perfect. So I'm going to talk to you about the protection and valuation of IP assets for tech scale-ups here in Switzerland. So thank you for the introduction. I'm an IP and tech attorney in Lausanne, Switzerland. And why Switzerland? Because Switzerland, as I said in the video, it has a very tech-supportive environment. Innovation is change that unlocks new value, said once Jamie Nutter. And Switzerland has this innovation culture, which is literally a virtuous circle where you have governmental support that also encourages entrepreneurs to bring effort and work and learning through universities and academia, which brings results, and then the circle continues, expands, and amplifies. I identified these six factors that actually makes Switzerland a nice place for innovation. First one is support to tech companies in terms of infrastructure. The second is a very good and foreseeable regulatory framework, thanks to this legislative approach in the forefront of innovation. Let me give you an example. 2017, 2018, there were many companies coming to Switzerland for issuing cryptocurrencies and using blockchain technology. So very quickly, the regulator issued some guidelines on how to consider this type of token issuance. And the Federal Council, the government, issued a very extensive report on the topic, considering amending the laws in order to encompass this new technology, and the law entered in force this year. I'm going to talk to you more extensively about it afterwards. Then the fourth element is governmental support for tech companies, and of course, as a place where we have a lot of financial institutions, banks, wealth managers, VCs, and private equity firms, there's great financing opportunities for startups and scale-ups, of course. And the ecosystem here is quite vibrant with multinational companies, SMEs, and startups, and the discussions on tech, and there's many events going on the tech issues. So let me talk to you a bit more about my topic, which is intellectual property. First of all, about the protection. IP protection serves really as the foundation of innovation in the Swiss economy. IP laws are designed to foster this innovation and to reduce the transaction costs between inventors and industry by providing information about the invention. In terms of statistics, there's more than 130,000 patents in force in Switzerland at the moment, which makes it the country with the most patent applications per million of inhabitants. Number of patent applications reached an all-time high of 988 in 2019. And in the list of countries who submitted the most applications in 2019 was Switzerland, ranks 7th, with only 8 million inhabitants in total. So for patent law, with respect to patent law, there's a really 5-step patent protection process. Filing, of course, the application, which includes a request as well as technical documents to be submitted, and an examination that will last during 18 months. And after 18 months, the patent application will be either rejected or accepted, and then the patent will be published with a priority period of 12 months in all Paris Convention countries. The substantive examination of the patent is really based on the technical documents, and you can always request an accelerated substantive examination that will allow you to actually obtain the results within the priority period. So within 12 months, you can get an initial input on your patent application, which is quite fast compared to other countries. So the patent is valid for 20 years, and it's published online and in the patent register. So the substantive examination will go through mainly the technical character of the invention. Does it solve a problem using technical means? And the grounds for refusal will be basically mostly formal. Is the invention presented in such a way that a person skilled in the art can understand it? Can the scope of protection being claimed be clearly understood, so that you need to have clarity in the description? Uniformity, are the patent claims linked through a common inventive concept? Do modifications go beyond the content of the original technical documents? And do the technical documents meet the formal requirements? So mainly the examination will be from a technical aspect and formal. And the Swiss Patent Office does not examine the novelty and inventive step. So you can ask for prior art research, which costs something like 500 francs, but it's a separate prior art research, which does not come into play for granting the patent. So the cost here for application 200, examination fee 500 francs, and then for each claim, additional claim, 50 francs, accelerated examination 200. So the costs are not extremely high for being granted a patent in Switzerland. Corporate law now. So as I said in the video, we have a new Corporate Act entered in force on April 2020. And as you may know, Switzerland is the seat of the Berne Convention, which is the early corporate protection convention. So what's protected? Computer programs, works of literature, art, neighboring rights of performing artists, producers, and broadcasting companies. How does it become protected? Automatically at the moment of creation, and the protection will be the life of the author or the public performance plus 70 years. And for software, it's the life of the developer plus 50 years. So also worth noting is that in Switzerland, copyrights to software will be automatically assigned to the employer by law. And the minimum requirement for copyright protection will be an individual character of the work or of the code. But for photographs now, they're protected irrespective whether they have or not individual character. Design law. So designs are protected if, to the extent that it is new and has individual character as well. And no individual character is recognized if the overall impression of the design it produces differs only in immaterial features from an existing design. So there's a lot of case law for watches here in Switzerland and for designs to watches, but other industries as well. And the duration of protection for designs is 5 years and may be extended for 4 periods of 5 years each. So I'm going to talk to you now about IP valuation. I think that's an important topic. To be able to value your IP asset, the asset should meet, in my opinion, the following conditions. It should be, well, separately identifiable, circumvented, which is subject to specific identification and recognizable description of the IP asset. There should be tangible evidence of the existence of the asset, so a contract, a license, a registration document, or simply financial statements, balance sheet showing that the asset has been activated. Should have been created at an identifiable point in time. It should be capable of being legally enforced and transfer assigned. Its income stream should be isolated from those of other business assets, if possible. The asset should be able to be sold independently of other business assets, and it should be subject to destruction or termination at an identifiable point in time. So these are, for me, the prerequisite to be able to value an IP asset. And valuing the IP asset has many advantages. First, for licensing or franchising UIP, you need to be able to define what license fee is going to be paid, and that will allow you to better adapt your contracts. Evaluating also IP asset will allow you to negotiate with academia, universities, institutes for tech transfer, know-how agreements. It will, of course, allow you to attract partners, but also to secure financing using the IP asset as a collateral for getting financing. And it's also useful to decide whether it's worth settling or not settling some disputes or some oppositions to your IP and some oppositions to some claims that may be currently challenged. So valuation methods, there's 3 main methods for valuing IP. One is the income method, which values IP asset on the basis of the amount of economic income that it is expected to generate, adjusted to its present day value. The market method is based on a comparison with the actual price paid for the transfer right of a similar IP asset under comparable circumstances. So you need to have comparables to apply this method. And the cost method is establish the value of an IP asset by calculating the cost of a similar IP asset. The cost method is useful when the IP can be easily reproduced and when the economic benefits of the asset cannot be accurately quantified. So these are the 3 methods, and you also have to take into account, of course, the R&D cost that have been invested in the specific IP asset. Let me now talk a bit about this blockchain act and IP and how it could relate to IP. First of all, I just want to explain to you how the Swiss regulator classifies tokens issued on the blockchain. So mainly there's a difference between native and non-native tokens. Native tokens are tokens that represent value on chain, so on the blockchain only, like Bitcoin, Ethereum, Tezos, which are issued by a blockchain protocol. And non-native tokens are tokens which represent value located outside the blockchain in the physical world. So let's say token that represent a piece of art or some type of property titles. Fungible, non-fungible tokens. So this is a topic that you may have heard, NFTs, which stands for non-fungible tokens. That means that these tokens are not transferable, not negotiable on secondary markets, and fungible tokens are negotiable. So basically, this has an impact on the qualification of the token in terms of securities law. Security asset tokens are tokens that represent shares, bonds, derivatives. In Switzerland now, we can issue shares of companies using blockchain technology and have the securities incorporated into tokens rather than physical certificates. Utility tokens are basically access rights to future service and services or products. So a company that has a platform, you can access the platform using its tokens. These are called utility tokens. Payment tokens are proper cryptocurrencies like Bitcoin, like cryptocurrencies that can be used as payment means of payment. And there could be hybrid tokens with several functionalities. So the regulator will check what are the characteristics and functionalities of the token to be able to qualify legally the token. And FINMA issued also some guidelines on stable coins. So stable coins are basically cryptocurrencies pegged with fiat currencies or with physical gold or other type of storage of value. And finally, CBDC stands for Central Bank Digital Currency. And this is the digital money issued by central banks. There's project to issue such money in China, in Europe, but also in Switzerland. So basically, the new DLT legal framework entered in force last February 1st, and the major change is that it allows transfer of rights, including potentially IP rights, license rights, using distributed ledger technology. So by transfer of right, I mean assignment of the rights. And until now, for assigning IP rights, you needed to have a written document with signature by hand to be able to assign the right. With this new law, you can assign this using a digital technology and the blockchain. So this paves the way for tokenization of all type of assets and rights, basically. And next August, September, it's not defined yet, but there's going to be a new financial infrastructure using the blockchain for trading securities and for clearing and settlement. So this really changes the way capital markets will function and really integrates distributed ledger technology in the finance ecosystem. Finally, I will talk about taxation. So I mentioned in the video, there's a patent box for SMEs active in research, development, and innovation, allowing basically these type of companies to deduct the research and development cost, but also the license fees from Swiss and foreign patents up to 90%, which has corresponding tax advantages. And the income tax will range from 20.5% to 22.5%, basically, depending on the canton where the company is located in Switzerland. But this is quite interesting for tech companies because it's lower than pretty much all the OECD countries in terms of taxes, corporate income tax. Thank you very much for your attention, and I'm happy to answer any question you may have. You have my details here. Do not hesitate to connect me on LinkedIn and keep in touch. I post quite a lot of things on these topics that I'm very passionate about.
Thank you, Florian. At this time, we'll open up the discussion for Q&A. If you have any questions, please feel free to type it in the chat box, and we'll be able to, and Florian will be able to address them. Okay, maybe I can start off with one question that comes up very often. Florian, we normally speak with a lot of young tech startups, and they're based in anywhere in the world, and they're looking probably to come to Europe and possibly Switzerland to set up their operations. So the question is that if they're doing a lot of their initial work in another country and a lot of R&D effort has gone into this, into their product in this country, when they want to move to Switzerland and they want to sort of register their IP there and manage their IP from Switzerland, does any amount of key functions need to be allocated to Switzerland? What part of this R&D can be sort of attached to the Swiss entity? How do they go about doing this transition? Does that impact where they've done their previous R&D for their IP?
Yeah, thank you. That's a very good question. I think if the IP is protected in another country, then you can assign it through an assignment agreement to the Swiss entity, and then basically that's a contract with the Swiss entity and the foreign entity, and then benefit from the patent box for license fees that would be generated by this IP. If the IP rights are not protected, but there's some work that has been done already, some research, then potentially you can evaluate this and use that as an in-kind for incorporating the Swiss company. So that could be based on an evaluation of an accounting expert. You can use this work, evaluate it, and use that as in-kind for the company incorporation. Company incorporation in Switzerland, you need to have 20,000 Swiss francs for LLCs and at least 50,000 for limited companies. So that could be useful to have some assets to put that as an in-kind for the incorporation. Does that answer your question?
It does. Thank you very much. Is there any other question that anybody would like to address? Okay, maybe just one last question that also has come up. In terms of adaptability or portability of these regulations, if a company based in Switzerland wants to use Switzerland as a base to deal with their clients all over Europe, what does that mean in terms of if you're covered by these regulations in Switzerland? How are you protected when you also deal with the rest of Europe?
You mean the blockchain regulations I talked about?
That's right, yeah.
Yeah, I think so. Basically, if the entity is based in Switzerland, the ledger will be held by this entity. So let's say you want to issue your shares using the blockchain. The shareholders' ledger held using distributed ledger technology will be held by the Swiss entity, and that will be basically run by Swiss law, so that's feasible. If let's say the token encapsulates IP rights or licenses, then also that will be operated by the Swiss entity that owns or that holds these IP rights and that licenses out to other companies in Europe. So I think the fact of being located here in the center of Europe will allow you then to use this technology for improving, the processes for IP valuation and IP protection, and also transfer of rights or license.
Thank you. We have one other question. If a company wants to launch a cryptocurrency in Switzerland, what sort of steps and measures should they take? Can they engage a regulator in advance as a part of their evaluation of where to set up and launch?
Yes. So basically, that's one aspect which is interesting for Switzerland as well. You can talk with the regulator. It's not like let's say in the US, the SEC. You can expose to the regulator how you interpreted what's your appreciation of the case of the cryptocurrency to be issued, and they will validate with the no action letter. That takes up to 3 months, basically, at the moment with the workload. But it's really good because you can issue your cryptocurrency without having to fear some enforcement measures afterwards. Basically, for foreign companies, because I advise many on this topic, for foreign companies to come to Switzerland, the initial step is to have a bank account. And open a bank account in Switzerland. You will go through due diligence, KYC and stuff. And basically being active in the crypto sphere was difficult back in 2018 to get a bank account. But now there's crypto banks that are regulated by FINMA and that are keen on opening bank accounts for crypto companies. So first step is open a bank account with this type of crypto bank, then incorporate the company, and then I do in all these type of cases a legal assessment of what is going to be issued. Is it a financial instrument? Is it a security? And basically, based on this legal assessment, then it's quite easy then to have this coin issued if you follow the recommendations. Basically. Does that answer your question, Daniel?
I think it was quite clear, your response. Thank you so much. So if there are no other questions at this stage, I'd like to sum up and thank you very much for your presentation today. What is definitely a takeaway is that technology and regulations are working relatively well hand in hand in Switzerland. We can definitely say it's a little bit ahead of the curve if you compare global standards. And the second important takeaway is that regulatory authorities in Switzerland are much more open-minded. They're able to engage in a more discussion-oriented view rather than sort of an authoritarian point of view at this point in time, which is definitely a plus point for a lot of young startups looking to scale up. We're very happy to take additional questions also offline. Please feel free to write to us or to Florian to get responses in the future as well. Thank you very much for your time and for joining us today. And thank you as well, Florian.
Thank you very much. And I will just share my details in the chat because this morning that was requested. And do not hesitate to keep in touch. I'm happy to continue discussions offline. Thank you.
Thank you. Bye, everybody.
Bye-bye. Bye.